tried stories, and he said, well, this is really dry stuff. So with that lead-in, my topic, ethics, attorney associations, responsibility, fee sharing. The other concern I have is I see a lot of white hair and a lot of people without much hair and a lot of folks out there that have much more experience than I do in this specific area. So some of this stuff is just plain common sense. Some of it is based on the rules. So if you find it something that just makes inherent sense to you, bear with me. All of this came to be because of an interesting decision by the Montana Supreme Court involving a very fine and real gutsy trial attorney from central Montana. And it came out and addressed Rule 1.5 of the professional rules. And it's something that I think caught a lot of people by surprise, because all of us, or many of us over the years, have associated on cases together. Sometimes we've been local counsel. Sometimes we've been requested by other Montana attorneys to help in a case. And generally, I think the practice was, if somebody approached you and said, I have this interesting case, I'd like you or your firm to help us on it. Here's the deal. Here's the facts of the case. Here's who we represent. And you'd jump on board if it seemed appropriate. And you never really were so concerned about whether or not there was a written fee agreement that not only existed between the original attorney and the client, but then some agreement in writing that sets forth the responsibilities between the referring attorney and the original attorney, or excuse me, the attorney willing to undertake the case. And that's where Rule 1.5 was discussed. And in defense of the fine attorney from central Montana that really doesn't need a defense, it was a situation where I think a couple of Texans were in Montana. They were injured. They went back to Texas. They knew an attorney in Louisiana from prior representation. That attorney then contacted the Montana attorney, and much to the credit of the Montana attorney, he filed the complaint, handled the case essentially on his own, and obtained a pretty remarkable verdict of about $870,000 in a very conservative venue. And then where the trouble came in was when the insurer agreed to pay the judgment, and there was some dispute about costs, and that's where the lack of a written agreement or lack of a written record as to exactly how it should be apportioned resulted. So all of you should read the rule and follow the rule. And I think even if it means perhaps going back and changing some written agreements, or at least supplementing those written agreements by way of a letter, you should do so. And certainly the client needs to be advised of the representation, the relationship, and the specific fee division between the two attorneys. So the rule is pretty straightforward, but what spun out of that when we started looking at the rule are some considerations about why you should associate or why you should not associate. Following Mr. Lazarus's suggestion, I think the one thing that needs to be repeated time and time again is any consideration in this regard, whether it's splitting a case or whether it's just handling a case on your own on a contingent fee basis. There's one overlapping, one predominant theory or thought that must control, and that is in every single case, is it in the client's best interest? And I think if that is first and foremost in your minds, there will never be any type of an ethical problem. Client first. And I think anybody who's been doing this long enough will tell you that if you always act on behalf of the client, put his interests first, the cases are going to come to you. And if you're interested about the monetary aspect of the practice, and let's face it, everybody has some interest there to support their families, put their kids through school, enjoy some of the better things of life, that's going to follow automatically from putting the client first. It's a little bit like when you see a football player score a touchdown and go into this big song and dance. The first thing that always comes to my mind is, why don't you act like you've been there before? And it's the same thing with any case you handle on a contingency fee basis. You shouldn't be quite so worried about maximizing your fee on any single case. Because if you treat the client right, if you do right by the client, those cases and those fees are going to come in. So back of the mind, client, back of the mind, attorney interest, top, front of the mind, client interest. So when is it appropriate to consider association? And it's something that has been going on in Montana for many years. I think the primary reason, in looking back, is it's a chance for mentoring. And I think it's a chance for mentoring not just of perhaps a younger or more inexperienced attorney, but I think there's great benefit to the white-haired attorney as well. And I think back of the people that I have great respect and admiration for, and they were all mentored. You look at some of the people that I think as a group we would acknowledge as being at the very top of their game. And I'll give you a list of folks that I always think of. And there's one common denominator with this group. You look at folks like Terry Treeweiler, Jim Regnier, Tom Lewis, Eric Thusen, Mike and Pat Cotter, Kurt Jackson, Xander Blewett, and there's one common denominator, and that's John Hoyt. And I think John Hoyt was a mentor to each and every one of those individuals. And thank goodness each and every one of those individuals continued on to mentor somebody else. I think of folks like Monty Beck, who I have great respect for. Early on in his career, he would associate with Terry Treeweiler, Jim Regnier. So there's great benefit to it. And I think there's also benefit to the client, because one of the professional rules talks about competence. And none of us are totally competent in all areas. Maybe none of us are very competent early on. So what better way to assure that you're competently representing your client at some stages of your career than to bring in somebody like that? And what a great benefit to the older attorney or the more experienced attorney to be able to mentor an individual like that. So from the client's perspective, from time to time, it's the right thing to do. One of the benefits to the white-hair attorney doing it is young attorneys have great, new, refreshing ideas. They've got a lot of energy. And there's, I think, a convenient curve where the experience goes up, but maybe the energy level drops. And the younger attorney meets you right there at the middle. And it's got a synergistic effect. And it's something that I think older attorneys should probably think about doing more. For example, let's say your practice is in Great Falls, but you've been asked to represent somebody in Polson, Montana. What a great opportunity to do a little research, find a good young attorney in the Polson area, and take advantage of that. Take advantage of that energy. Take advantage of that person being able to go out, meet the witnesses, do a lot of things that you may not have the time to do. And I would encourage everyone with a little bit of white hair to consider that. other advantage of considering association is there are certain folks in our organization that have substantial expertise and experience in scientific matters, engineering matters, medical, and on some cases, it might very well be wise to consider drawing into that base of knowledge. You've got nothing to lose and much to gain. There's also the consideration of costs and the scope or the breadth of any single case. There are some cases that are now being undertaken by members of our organization that are just extremely complicated, time-consuming, and expensive. And I think when you're considering the best interests of the client, part of that is, do you have, first of all, enough staff, enough attorneys to handle that type of a case? Or do you have the financial wherewithal to hire the experts that may be required to at least give yourself and your client the best chance of getting the case home? So that's another consideration. The final, or a final perspective from the senior attorney, I know when we've been brought in on some cases, when you go and take the depositions of perhaps a corporate representative under Rule 30b-6, or a very important witness, and you've got the younger attorney with you, there's a little bit of pressure on the older attorney to do well. And sometimes we get sloppy in our work habits. Maybe you've taken that same kind of deposition 10, 20 times. But if you've got somebody there that is working with you on the case, at least from my perspective, you prepare even more because you want to look good. And maybe that's a tad bit of ego, but it's a good bit of ego because it enhances the client's case. And you show up with your A game instead of maybe your B game. I think those are all important considerations. We've been on both sides where we've worked some cases with out-of-state counsel, worked up cases with our colleagues here in Montana. Frequently, there's 4 or 5 people around the state that we just handle the case with them, and we just each have our specific area of expertise. You can rely on the person because you're fully confident that they're going to do their work, you're going to do your work. But there's some things I think you need to do whenever you're put into that position, whether you're supposedly the more experienced or supposedly the less inexperienced. The first thing you need to do is to make sure that the client is fully aware of this. We've all heard horror stories of certain out-of-state counsel coming into a Montana courtroom or a Montana settlement conference, having never met the client. And that's obviously not a good thing. You need to meet with the client, certainly obtain their approval, explain to them why this is being done, explain to them why it's beneficial to their case or to their cause, and get approval. You also need, early on, for this arrangement to be beneficial, I think you need to delegate or have a clear delegation of responsibilities between the attorneys. You're not going to benefit your client if all you're doing is duplicating effort. And so early on, I think it's important. It doesn't necessarily need to be in writing, but you need to have the talk right away about who's going to do what and who's going to be responsible for what, and have a clear delineation. You also need, I think, to appoint, in some sense, that somebody will be lead counsel for certain functions, because you need to be on the same sheet of music. If there's going to be one person who's going to be essentially the liaison with the client, tell the client that and say, if you've got concerns, you should try to contact John. If John isn't available, then contact Rich. That type of an arrangement. You need to have one person, I think, who's going to be primary with the court in all communications with the court staff. There's nothing more embarrassing if some kind of an agreement is reached with the court, some stipulation or between counsel that one of the counsel is not aware of. He proceeds as if it doesn't exist and then is somewhat embarrassed when it turns out that there's already an arrangement in place. The same thing with contacts with the media. I can give you an example where, if you're in a case involving federal court diversity jurisdiction, you have a local defendant. That local defendant defeats diversity. The defendant, though, the foreign defendant, brings some type of a case for a claim of fraudulent joinder. The last thing you want is somebody having communications with the media indicating that Joe Blow, the local defendant, was only added for purposes of strategy. And those types of things can happen if you're not communicating back and forth between counsel. I think it's also important that you have one person primarily responsible for communicating with the other side, for the reasons that I just mentioned. If you don't, you can have certain situations, and you even see it in individual firms, where defense counsel thinks he's got a better relationship with one of the attorneys in the firm than the other, and is always contacting that person for whatever reason. And that can create conflict not only between opposing counsel, but between members of the same firm or associated counsel. What not to do. You don't want to create unnecessary work. You don't want to duplicate work, and you don't want to unnecessarily increase costs, because the only reason you're going to do this is for the benefit of the client. One thing that you see from time to time is, and depending on the fee splitting relationship or mechanism, and let me ask you, how many people keep track of their time on contingent fee cases? And why do you do so? Don?
The reason I do, Dave, is because I'm in a firm where we've got a lot of hourly billing people, and that's one of the ways to keep track of it. It also shows me statistically which cases I do better on and which I don't.
Yeah. Well, part of the rule says that if you don't have a provision in your agreement with associated counsel that you're both jointly responsible for the case, then there has to be some determination when dividing the fee as to the time or the effort spent on the file. Personally, I've never been a fan of keeping track of contingent fee cases for a variety of reasons. The primary one is, I think if you're going to operate a contingent fee practice, there's going to be cases where you may have 2 trials, a couple of appeals, all sorts of time. And if you were to track what your hourly rate was, it could be $1 an hour, and it could be disturbing to you. Whereas there's other cases where if you did the same calculation, it would seem like you're making out like a bandit. But the only way, in my view, that you can even justify a contingent fee agreement in addition to providing people access to the courts, is that you got to take the tough cases along with the cases that turn out not to be so tough. So I would suggest in that agreement, more often than not, that you put some language in there that both attorneys are jointly responsible. But that also then raises the question of what about the brokering of cases? And I was not able to find a Montana decision that talked about the situation we all see where somebody has a client come in, they commit them to a contingent fee agreement, and then they refer that case to Montana counsel and never touch it again. I think when you look at Rule 1.5, that is, if you implicitly, I think that is barred. Because at that point in time, there is not joint responsibility for the case. They're not on the caption, they're not in the court pleadings, they're not working the case up. All they've done is refer it. And I think if you read Rule 1.5 as it's intended, I think the fee would be limited to the actual time spent by the referring attorney, which might be the time to bring the client in, take an intake interview, and sign the client up. Different people are obviously going to have different views of that, and I know it happens nationwide. Perhaps there's different ethical rules in different states, but that's certainly the way I would read the rule. And what benefit is there if you're going to associate, if you're not going to work the case up together? I mean, I think that's the only reason to do this. And I think it's the only way that benefits the client and both attorneys involved. That gets us through the association. Read the rule. But I wanted to talk a little bit about contingent fees. And we've got time. And hopefully we'll have some time for some questions and maybe get out of here just a tad bit early too. What a wonderful vehicle the contingent fee agreement is. And in the outline, I've referenced the Montana Supreme Court's decision, I believe in the Bell and Mara case, that talks about how important the contingent fee agreement is and the basis for it. But we've all heard the term, it's the poor man's key to the courthouse. And I think that might have been true 30 years ago, but now I think it's essentially every person's key and only key to the courthouse. If you represent small business, even if you represent the well-to-do, and if their case is against a large multinational corporation, some vested interest, I don't care how much money you have as a Montana business or person, the table still isn't level. You're terribly leveraged by the defense. And even small business, successful small business, typically can't go out and hire an attorney at some fair hourly rate to pursue those types of claims. So not only is it the poor man's key, it's everyone's key to the courthouse, but just as importantly, and not to be forgotten, it's our means as trial attorneys, and the only means to be able to join the fray, to be able to take on the cause, and to devote perhaps the next 2 or 3 years of your life to try to assure some sense of justice for this person. We can't, in my opinion, exist without the contingent fee agreement. It would essentially dry up what we do, and I think it would essentially result in justice being denied, essentially across our country. So what do you do in response to that? Because the contingent fee agreement is under attack and has been under attack. And it's a precious tool, and sometimes even the most enlightened of us have pushed certain things maybe a little too far, maybe a little too quick. And when that happens, there's sometimes a legislative response. There can be a judicial response. So I think the lesson to be learned is if you've got a precious tool, you handle it as such, and you deal with it fairly, and you abide by the terms of it. And how do you do that? I think the main thing you keep in mind, always keep in mind, what's in your client's best interest. Your client has one case, sometimes two or three. You're going to have, at any point in time, maybe 50 cases. The young people in this audience, over the course of their careers, are going to have thousands of cases. So that's why the client comes first, because he's got one chance. You've got many. So don't, and this is a little preachy, and the best thing about the preachy part is you can reject it, set it aside, but at least listen to it. The best thing to do is don't overreach. You hear stories from former clients, hopefully not mine, but perhaps. And a sad thing to hear is, Joe's out there talking about his case. Maybe it's a FELA case he had. Maybe it was a personal injury case, maybe medical malpractice. And a friend or a family member will say, well, Joe, how did you do on your case? Well, I did okay, but boy, my attorney really did good. He got more than I did. And that can happen if you follow the agreement to a T. But it shouldn't, because I don't care if your advertising is a website or a bus bench or the front or back of a phone book. That might all be effective advertising, but I believe the best advertising is still word of mouth from former clients. And they're going to ask Joe, how in the hell did, Jory do for you? And if Joe can say, Jory fought a great battle for me, maybe the case didn't come out quite as good as we expected, but he was fair to me. And how do you be fair? We have one philosophy in our office, and I think it's a pretty damn good philosophy, and it came from my partner Tom Lewis, and I don't know where he got it. I'm guessing probably from John Hoyt, and who knows where John Hoyt got it. But that is, we always make sure the client does better than we do. And fortunately, in most cases, that hasn't been a problem. But occasionally, and I'll give you an example, it was a case I had, products liability case involving a ladder. And it was a tough liability situation. And I hired a great expert, and the expert came back and said, well, their experts have all of these studies where they show people using ladders as pogo sticks, and the ladders they're wonderful. They don't crumple, they don't do anything else. So I want to hire some of my graduate students, and we'll put them on ladders, and we'll have protective lanyards so that we don't break their legs. And we'll put them on these ladders, but then we're going to shift their weight a little bit so they load one side of the column more than the other. And I think what this is going to show is that these ladders crumble, especially if somebody's hanging on to a can of paint or something. So we fund the study, and I thought it was a damn good case, a great plaintiff, great guy. He was a friend, he was a beer truck driver, and he was probably the best beer truck driver in Great Falls. His boss said, Joe is the best guy we have. He's dependable. He hauls the kegs, he hauls the cases of beer. The vendors love him. And he had terribly complicated fracture of the wrist involving all sorts of bones and ligaments and everything else. And I thought, I asked my friend who owned the distributorship, I said, well, if Joe can't work as as a beer truck delivery man, what's he going to be able to do? And Kevin said, Joe's the best beer truck driver, but, that's kind of the top of the game for Joe. He's not going to be able to transition in to a management position or even a supervisory position. It's not Joe. So we proceed with the case, and I spend this money on this study. And Joe has his wrist worked on by a local orthopedic surgeon, and he gets a great result. I thought there's no way he's going to be lifting kegs. And 15 years later, he's still lifting kegs. The damages just kind of went like this. The costs were up here, damages here. And we made the best recovery we could. But if we had taken a fee and paid the costs, there would have been more money coming to Lewis, Slovak, and Kovacic than to Joe. So what do? I suggest to you, you waive the fee. And I don't care if you've got 2 years into it, but you make sure after you recover your costs that your client does better than you. And if Joe is out there today talking to people, he'll say, yeah, fortunately I had a good medical result. We didn't get, what we had originally anticipated, but those guys were fair with me. And damn if they didn't waive their fee. Now, you don't want to do that in each and every case, because then you're not around to advance justice because you're not going to be in business. But when the situation is right, I think it's the right thing to do. And how do you justify it? One, you have a good client who's happy or at least satisfied with your results, who hopefully will talk to other people. Word of mouth is still the best. But I said, wow, what a great lesson. This was invaluable because next time I have a ladder case, I've got a good expert. I already got this study done. And if nothing else, I've also learned a lesson that maybe you'll want to see what the medical and the damages look like long term before you invest the money. So I didn't count it as a loss. I just thought it was a good learning experience. And even my partners were okay with that. Other things about contingent fees. I think you need to have a happy and satisfied client. I think you need to discuss with them the purpose of the contingent fee, how it's in their best interests, what'll happen if there's a successful recovery. And at the time, either when you divide up the judgment on following a successful verdict and appeal, or a settlement, and especially in the instance of a structured settlement. Sometimes structured settlements are the very best thing for your client. In certain situations, I think it's maybe the only way you can really ethically protect that person, whether it's because of age or disability. But when you do that settlement statement, and you have this significant recovery, and then you've got the fees and costs, and then there's a certain portion that is devoted to essentially the premium to structure the annuity, and then you have the net amount after all that. You need to explain that to your client and demonstrate to that client what the payout is over the structure and what the benefit is. Because otherwise, they'll look at the settlement statement a year later and go, oh my God, what happened here? So education, I think, is important to the client. Back again to the purpose of the contingent fee. And another consideration is costs. We think if the case is good enough to take, if you're willing to invest the time, you should also be willing to invest the costs. And I don't see any basis for a situation where, if things go south, where there's an effort to obtain or recover the cost from the client. I've heard of that, and I've heard of people claiming interest on the costs and such. Back to the client's best interests, you have many, many cases he or she has won. The risk of the cost should be on the attorney. The other reason you want to do that is you want to be in a position where you can expend the funds to hire the type of experts or to do the type of preparation that gives you and the client the best chance of success. So keep those costs within your province, and if things do go south, eat those costs and don't seek recovery. And that's another, certainly the rule doesn't necessarily require that, but I think in the long run you're best served by that. Think about some goodwill things. If you make a successful recovery, for whatever reason, clients frequently are somewhat insulated from all the work that you did to get there. You can send them copies of the pleadings, the briefs, and such. They really don't realize how much work you've put into the case unless it goes to a trial. And then they see all the paperwork, they see the trial preparation, they see the actual trial. And it's not unusual for them to say, geez, I didn't know it was this involved. I didn't know you had to work this hard to get a result. So keep them advised of the work as you go, as much as you can. But if you get that successful result, I don't think there's a better feeling in the world than to say, you know, Joe, we did pretty good here. And you did good and we did good. And we're going to, in light of that, we're going to contribute $5,000 to something related to the case. Or if you've got a group of clients, you know, throw a buffet dinner at the conclusion of it. I know after the first round of Sunburst, we went up to, well, we didn't go to Sunburst because there was no place to have the buffet. But we went to Shelby, and it was around Christmas time. And everybody was appreciative of our efforts. But they were most appreciative of the fact that we thought enough of them that we wanted to throw them a dinner and to eat dinner with them. And I think that has more positive client relationship, public relations, than any other gathering or any other effort. So many times the case closes and you're done. And you may not even see the client again for another year or so. And I think there's some separation anxiety. You spend all this time together and then all of a sudden the case is closed and the client never hears from you again. You may have a situation where somebody was injured, or I can think of a situation where we represented a lineman electrocuted, represented the family, and shaved off a little bit of the fee in order to contribute it to a memorial fund that had been established in the lineman's honor. That stuff goes so far. And I think it's part of our obligation to advance that and to justify contingent fees from time to time. I listed in my outline Father Doyle, and there's probably only a person or two in here who might know Father Doyle. I know Justice Cotter does, and I have to say Justice Cotter knows Father Doyle because she attended Mass at St. Anne's Cathedral. I know Father Doyle from a different perspective because I don't attend Mass at St. Anne's. But our office, which Tom Lewis and Jim Regnier purchased from the diocese, is the bishops. I think the term is chancery. So we're on the other end of the block from St. Anne's and Father Doyle. He's a delightful person, and has fallen away several times over Catholic. I'd always talk to him, and we donated to the soup kitchen and some renovation of the cathedral. And so I'd see him, and he'd at least recognize me. And I was down there working on a Sunday before a trial, and he'd say, "Dave, what are you doing working on the Sabbath?" And I said, "Well, Father, we got this trial, and it starts tomorrow." He said, "Well, tell me something about it." And so I told him a little bit about it. And then I thought, well, Father, you know, it's a pretty tough case, and we could use any help we could get. So, you know, if you could maybe keep us, you know, at least in your thoughts, if not your prayers. And he looked at me and he said, "Well, who's the case against?" And I said, "Well, it's that big international, you know, petroleum company." And he said, "Well, tell me the name." So I told him the name. He looked at me and said, "Boy, we don't have any affiliation with Texaco. I'll be lighting a candle for you." So it came out good, and he lit the candle. And I don't know if this is a breach of what maybe caused Martin Luther to separate from the church way back when, but so we kicked in a little more toward the renovation fund. And, you know, I think anything you can do in that regard to put a positive spin on what we do with your clients, with the community, is so valuable, and it costs so little in the whole scheme of things. And when the contingent fee agreement is under attack, and it is so vital to what we do, you know, go to bat for it. And on a maybe less positive note, don't abuse it. How am I doing on time? You know, don't abuse it. We've got all these cases. We're going to have more. Your client's got the one. Client's best interest. Don't overreach. Now, I don't care necessarily what the rule says or what your specific agreement says, but if somebody comes in and they're injured, or maybe they've lost a loved one, and through the fault of another, and that tortfeasor, wrongdoer, has a $100,000 limit, and there's no other available means to mitigate the loss, let alone make the person whole, and you write a letter or two, and the insurer pays the $100,000. I don't care if you got an agreement that says you're entitled to a third. You know, don't do it. Think about, in your own mind, how much of this recovery was really due to my efforts? And how much of it just fell in our lap because we had this tragic situation where somebody lost their life and there wasn't enough insurance? So think about, you know, how much is really as a result of my efforts, and don't overreach. Nobody may even hear of it, but I think you'll sleep better at night, and I know you'll have a much happier client. And that same client is going to say, "Boy, I was in a real bad spot, and I lost my husband, and there was only $100,000 worth of insurance. And this attorney took my case, and he wrote 1 or 2 letters, and he got the money, and he didn't take a fee." Those are the stories you need when you're all the bad stuff, supposedly, about the contingent fee agreement. And if you live by that, the contingent fee agreement will continue to live and prosper as it should. That's a little preachy, but I got a pulpit here, so. Any questions? Tom?
How do you deal with court-awarded fees?
Oh, that's in my outline. I've always thought, at least in the work comp context, that, and this follows with Don's comment, some cases you probably need to keep track of your time. I've always thought that if there's a court-awarded fee and you've got a contingent fee agreement in place, anything that is court-awarded is simply offset from the obligation, the client's obligation under the contingent fee agreement. So if, let's say you have a $50,000, $60,000 recovery in comp court, for example, and the comp court orders the payment of fees on an hourly basis and awards $7,000, and the 20% fee in the comp would be $12,000. You simply subtract that 7 from the 12, and the client's obligation is an additional 5. The one thing that's interesting is none of these rules are totally solid and hard. Occasionally you'll have a client who has a case where the value on a best case basis may not be that great monetarily, but it may have significance on a number of other fronts. You may be advancing the law, you may be just getting that person's job back. And there might be a provision in the law that allows you to secure attorney's fees. And sometimes the defendant's obligation or exposure for attorney's fees is much greater than what the client can actually recover. And that's a spot where you need to have some client education and say, hey, I'd love to pursue this case for you, we will do it, but you need to know that if they take us to the mat and we have to try it and go through these administrative hearings, they may be responsible for fees, and your recovery might be $30,000 in your job back, but their exposure for fees may be $100,000. And in that situation, I think you just need to explain that to the client and say, I'm willing to do it, but you got to know that when push comes to shove and if we're totally successful, the recovery for the fees may be greater than your individual recovery. And there's some cases where you might have a client, we call them principal cases, where they just want to take it on because it's a matter of principle, and you have the same situation in that. But you need to educate the client, make sure they're still comfortable in proceeding forward. Mike.
David, we've had a couple of people come in, plaintiffs who were represented by others, not state lawyers, in specific situations, where they had a contingency fee agreement and the case was processed and handed it over. And then they got the fee bill at the end and they found out the costs in the case had included independent investigation, for example, rather than the law firm doing it, they farmed it out. And so there's a bill in there for $10,000 or $15,000 for someone to have done the investigation that we would do in our own office. Similarly, medical expenses, they hired an independent nurse or a medical consultant on an hourly basis to collect all the medical records, collate them, organize them, interpret them, and that sort of thing. And once again, end up with a significant fee bill, which would ordinarily, in our office, would just be part of what we would do. And I guess you can do what you want, but in these cases, these people were in our office looking for a remedy against the person who had represented him. Through that, I think you could comment on the education process, because I think those sorts of things do damage to the contingency fee, like you're talking about,
Yep.
respect for the justice system. But if people know going in what the costs are, and you keep them apprised of significant costs before they're incurred, and certainly explain to them at the beginning, why I think a lot of that's avoidable, but I'd like to comment.
Yeah, you're dead right. You need to educate the client as to what costs may or may not be necessary for their case. And it's always if there's a problem down the road, it's always because of a lack of communication. We've been using a lot of life care planners on a variety of cases. And I think it's important that you explain to the client the function of the life care planner, the fact that you are paying out-of-pocket expenses to this person to do a certain function. When the client, I think, has a concern is when they get their settlement statement, and breaks out the costs. We usually include an itemization line by line of each cost. And they see some big figure and wonder, I never even talked to Professor so-and-so, how could we be billed $10,000 for this? And I'm sure it's different from firm to firm, but whether you, I guess the term of art nowadays is outsource, whether you outsource something, I think that determination has to be made with the client's best interests at heart. It may be easier to pay somebody $5,000 to compile medical records, but if you can do it in-house, I think it's incumbent upon you to do it, unless there's exceptional circumstances. But you certainly need to continue to tell the client what the costs are and why they're being incurred.
Annual update. As is typically the case, there are a bunch of kinds of cases I'm not going to address this morning. Divorce, criminal law, real estate cases. We frequently comment at the court that we'd be a lot happier if we